In Ghana, when you die, there are two things that become very apparent. One, you would have left behind a will, or you will not have left behind a will. Now, when you die and left behind a will, it is quite clear that a will will determine how your properties will be distributed and how certain matters will be handled after your death. But what happens if I don't make a will before I die? Or if you don't make a will before you die, what happens? In this video, I'll tell you all of that and more. I'm Godwin Salasi Dapo, and this is Make It Legal. Make it legal. If you die and left behind a will, the will governs everything pertaining to the properties you own, so long as you have actually indicated in the will that all your property should be taken care of in this way or that way. But if you die without making a will, there is a law in this country which is called the PNDC Law 111. You might have heard of this law, even if you are not a lawyer. The PNDC Law 111, a law that was made since 1985 to regulate the distribution of properties in a fair and equitable manner and in accordance with that law, in order to avoid the troubles that the lack of a will and the inadequacy of laws to regulate the distribution of properties of persons who die without making a will. So that law is actually called the Interstate Succession Act of 1985, Act 111. In fact, as a matter of law, we are not supposed to be calling laws in Ghana as PNDC law, something decree or something others. We are not supposed to be calling laws like that. We are supposed to call laws as acts. That's laws that are acts of parliament or enactment are supposed to be called acts with the number, maybe Act 111 in this case. That's the PNDC law 111. We're supposed to call it Act 111 or Interstate Succession Act of 1985. But for the purpose of this video, we would refer to it as PNDC law 111 so that we can all be on the same page, because we know it as PNDC law 111 and then we just don't want to let it go. So lawyers oftentimes refer to it still as PNDC law 111. And I also want to do same, because I'm a lawyer, I can also refer to it like that in this video, especially for you to be able to understand and be on the same page with me. So I'm going to take you through how your properties will be handled in accordance with this law. If you die without making a will, you have the option to avoid the application of this law by simply making a will. That's why I made a video for you on what are wills and why you should make one. The link is right here. Check it out and watch that video and understand the implications of making a will and see if you can make one, or approach a lawyer to make one for you. But if you don't make a will and you die, this is what is going to happen. When you're in your grave resting or you are with the Lord, this is what is going to happen behind you. So when you die without making a will, the PNDC law 111 will regulate the distribution of your properties. And there are some things I want you to know. This is how it's going to happen. Now, first of all, there are what I call special provisions that must be taken care of first before the rest of the estate. Estate here refers to what you left behind after death. It's called your estate. So before your estate is taken care of or is taken over and distributed to people in accordance with the PNDC law 111, these three things must be taken care of. The first one is what we call the household chattels. Now, if you have household chattels and you die without making a will, all those household chattels will be given to your surviving spouse or surviving children or child, or both of them. Now, what are household chattels in the first place? They refer to everything you may enter the room and just see. The furnitures and furnishings, the fans, your shirts, your personal effects, all of those things that you have are your household chattels. And they'll be given to your surviving spouse. If it's a husband or a wife, he or she will take it. And then if you have a surviving child, he or she will take it. So they will take the household chattels first of all. I mean, that is very important to know, so that when your husband or wife dies and he has not left behind a will, you must know that as far as the law is concerned, you must be giving all of his household chattels or her household chattels, depending on the person who dies. Now, the second thing I need to know, which is part of the special provisions, is that when the person dies intestate and has only one house in his estate, the law is that that single house must be given to you as a surviving spouse, or to you as a surviving child or children, or both of you. When both of you take it, you must hold it as tenants in common. Tenants in common means that all of you enjoy it together, but the day either the surviving spouse or the surviving child, any of them, dies, then whatever portion he's entitled to, his equal share in that house will be passed on to his or her estate. The entire house will not be the surviving person's property. Whatever equal portion that's supposed to go to the other person, either a child or surviving spouse, will be given to his or her estate. So the two of you, either surviving spouse or surviving child, if any, would hold the one house that the intestate has as tenants in common. The third thing I need you to know, which is part of the special provisions, what I call the special provisions, is that when the intestate has more than one house in his estate, you are entitled to choose the one you prefer before the remaining one goes into the distribution under the general provisions I'll talk about later. So you are entitled to choose. And when I say you here, I'm referring to the surviving spouse or the surviving children or child, or both the surviving spouse and the surviving child or children. So you are supposed to elect one. You must all come together and say, we want the house at East Legon, we want the one at Shy Hills, or we want the one at Medina, or we want the one at Spinter. So you choose the one that you think you like. You must choose first before the distribution kicks in under the PNDC law. That is very important. Now, what happens if you are unable to agree to choose a particular house? The rule is that the persons who are called administrators would have to apply to the court, the high court in this case, for the high court to make a decision as to which of the houses should be given to you. So if you are a surviving spouse or surviving child or children and you're unable to choose the house out of the many houses the deceased person or the intestate has, the court would sort of give you one, impose one on you as the law permits. Or you could go to the court and show why a particular one is the one you want. Or if there is a disagreement between the surviving spouses or surviving children as to which one they should choose, the court can resolve the disagreement when an application is made to the court to so resolve it. It's important I mention that when the law talks about child, referring to both natural children or natural child here means somebody you've given birth to, your own child. But the law also includes adopted children as part of these children. They are persons who are your legal children. They've also become your children by law, and forever they remain your children. They are also entitled to inherit from your estate, so they qualify to be part of surviving children. And the law oftentimes also recognizes other persons who you have recognized during your lifetime to be your child under customary law, or persons who by law are recognized as children. They are also part of your children. And when we talk about spouses here or surviving spouse, we're referring to a wife or a husband who is alive. And it could be many wives in Ghana, but certainly it cannot be many husbands because Ghanaian law prohibits one woman from marrying many men. So for a man, it can be many women who are the spouses. If they are 5 or 10, they will share that portion that is going to the surviving spouse. They will share all of that. If the children are 20 or 10, they will take that portion that is going to the surviving child or children. They would share it. Those 3 points I mentioned are for the special provisions, things that must be taken care of first of all before the properties are distributed in accordance with the formula given by the PNDC Law 101. So I'm going to take you through the formula in various categories. When the person dies having only a surviving spouse or surviving child. What if he died without having any parent alive? What if customary law does not apply to his estate? What if the person dies without having a child, a spouse, no parent alive, and no customary law applies to his estate? What is going to happen? All of that will be discussed with you in a few seconds. Hey, if you're enjoying this video, don't forget to subscribe to the channel. You see this subscription button, click on it. Some of you are afraid to click it. Many of you watch the videos and just bypass it. No, when you're done watching videos, you click on subscription. You see that one there, you click it. Yes. Now let's take the first provision as far as the distribution of properties are concerned. So the first category is where the person dies and he or she is survived by a spouse and a child after the remaining portion of the estate, after taking care of the special provisions. How will it be distributed? The law is that first of all, 3/16 of the estate must go to the surviving spouse. Then 9/16 goes to the surviving child or children. And then 1/8 goes to the surviving parent. And then 1/8 distributed in accordance with customary law of the person who died. However, if the person, although survived by a spouse and a child, does not have any parent, 1/4 of the estate will be distributed in accordance with customary law. The second thing you should know is that when the intestate is survived by only a spouse, this is how the distribution is done. First, half of the estate goes to the surviving spouse. then 1/4 goes to the surviving parent, and then 1/4 again goes to or is distributed in accordance with customary law of the person who died, the intestate. But where there is no surviving parent in this category, half of the estate will be distributed in accordance with the customary law, or half goes to the surviving spouse. Remember, there's no surviving child in this scenario. The third one is that the person is survived by only a child or children. No surviving spouse are there, but they are surviving parent. Don't forget that. So, as far as this one is concerned, the distribution goes like this: 3/4 of the estate will go to the surviving children or child. Then 1/8 will go to the surviving parents, and then 1/8 will be distributed in accordance with the customary law of the intestate. But where there are no surviving parents, the 1/4 would be given to or will be distributed in accordance with the customary law. Now, what that means is that the community the deceased person belonged, that customary law of that community, who inherit property from the person who dies in that customary law, that is what it means that it should be distributed in accordance with customary law. Maybe in that community, their customary law is that when a man dies, his brother succeeds or takes over his properties. So whatever the brother is to take under customary law will just be what the law prescribes here. Not that he will take everything in the family. No. The surviving children, parents, and spouses must take their share. And then whatever the law says should be given in accordance with customary law will be given to that particular person who succeeds the deceased person or the intestate. The fourth one is where the intestate is survived by parents only. No child, no spouse. Only parents are alive. Now, when that becomes the case, 3/4 of the estate goes directly to the parent, and then 1/4 shared in accordance with the customary law. That is the law. So when there is only a parent that the deceased or the intestate is survived by, it is distributed in accordance with this under the PNDC law. 3/4 goes to the parents who are alive, and then 1/4 goes to the customary successors or distributed in accordance with customary law. The fifth category is where there is no customary law to be applicable to the estate. The person who dies, as far as he is concerned or his community is concerned, there's no customary law that says that when someone dies in this community, the person who inherits him in customary law is this person, is that auntie or that uncle. If there's no such law, what happens is that whatever the law has apportioned to be applicable under customary law will be taken and shared equally among all the persons who are distributing under the previous categories we mentioned. So if there are surviving children who are distributing, the share that is due to be distributed in accordance with customary law will be given to those children in equal share. That is how it is. What happens if the person is not survived by a parent, a child, or any spouse? Neither spouse, child, nor parent is there. What happens? The rule is that first, all the estate would go to the customary successors or will be distributed in accordance with the customary law. Or if the customary law is not applicable to the person as well, then all the estate will go to the Republic of Ghana. The seventh general provision I wanted to note is that where the person has a very small estate and the law view as an estate which is only 50,000 Ghana cedis as a small estate. So once your estate is just 50,000 Ghana cedis, the law says that it is a small estate. And for small estate, the estate should go to a surviving child, surviving spouse, or surviving parent. Either of these persons should take it. This is the last one I want you to note, and this is very important. It's a bit technical, so pay attention to understand it. Now, if you are the grandchild of the intestate and your mother is dead, and your mother died before the intestate dies, and then you can show that as a grandchild, you were depending on your grandmom who is now dead, or your granddad who is now dead. Whatever your granddad would have given to your mom as the child would be given to you. I hope that is clear enough. So if you are the grandchild of the one who died, the intestate, and your mom actually died before your grandmom or your grandfather died, if you can show that once your mom died and your grandmom was alive, you were dependent on your grandmom, whatever is due your mother will be given to you as a grandchild of the intestate. We've come to the end of this video. These are the things that will happen if you die without making a will. I believe you enjoyed this video. Get a friend to know about this channel and to know about this video. The law requires you to ensure that you share Make It Legal videos and then you subscribe to Make It Legal channel. So do so now, like it and share it. The law requires requires you, my law. I'm Gode Salasidapo, and this is Make It Legal. Make it legal.